Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about the helpful guide to Section 341 bankruptcy hearings by Dr. Brenna Evans, a Lifeback Law lawyer. So these bankruptcy hearings, and it's a little bit of a misnomer. We call them first meeting of creditors, even though there's not a second typically. And we call them meeting of creditors, even though most of the time creditors don't show up. But there's a couple of ground rules for appearing at Section 341 hearings, bankruptcy hearings. Section 341, of course, refers to the Bankruptcy Code provisions which require attendance at a bankruptcy hearing after you file petition and schedules. One rule is make sure that you appear early and that you make sure you're in a quiet space with no background noise. And make sure you're polite. Look, these are not combative hearings. The purpose of this hearing is to determine that all your assets and debts are disclosed, and for a trustee to ask any questions they might have. Because when you do this, you're an open book. You can't go into bankruptcy going, well, I'm not going to disclose my bicycle. I'm not going to disclose my Harley. I'm going to disclose everything, but I'm not going to disclose my house. You can't do that. You must disclose everything. You must be completely forthright in what you have for assets and debts. But when you do that, these hearings are pretty uneventful. But those are some of the ground rules when the time is right, when you are ready to get your life back. Reach out to Lifeback Law Firm. You're going to be so thankful you did.